Hello, good morning, and welcome to all of you that are here with us today. We have the great pleasure of once again seeing with us Professor Laura Clérico, that has been present at many of the events of the center since some years now, and she continues being present. Hence, it's of great joy to see her with us today during this fourth day of transmission concerning the international talk. She's a professor from the Law School of the University of Buenos Aires in Argentina and from the Nürnberg University in Germany. And today she will be addressing economic rights, social and proportionality to all of you that are here with us through social networks. And from the legal culture departments, you can convey your questions through the stipulated path in each one of these platforms. With no further ado, Laura Clérico has the floor. Thank you very much. Thank you. Good morning. First of all, good evening to all of you. I hope you're all doing fine. And thank you, Diana Beatriz Gonzalez, for your introduction and, of course, for being present with me today, providing support with regards to answers to questions, as well as for the invitation conveyed, and to the Study Center, Constitutional Studies Center. I will be sharing my screen with you with my slides, and you will let me know if you can see it properly. Yes, we can see it. As I was saying, or Diana was saying, this is not the first time that we're sharing this space. So this is a sort of continuation of some of the conversations that we have held with the group that gathers this Constitutional Center of the Mexican Court. And because this is a conversation, we shall continue with it. What I wish to share with you is precisely the relationship that we see between the examination of proportionality, economic rights, and gender as well, but not in an abstract manner, but rather from the Latin American context. And on the other hand, not only focusing on the courts, I wish to talk with you with regards to this relationship, and to be able to talk with you about this relationship. To begin with, you shall see why context and challenges, and why what I call the coupling. And this will allow me to present the question with regards to this conversation, to define the work perspective as well, and to work on the relevance, therefore, of the proportionality test under the light of the question that I shall be asking within these three modalities. For example, excess, regression, and insufficiency. And thereafter, I shall provide you with conclusions. We are talking about the proportionality test. We start from the structure, the standard structure of the test, which exists. It consists, and from an analytical point of view, it's 4 steps. You can see them here on the slide. And the first question refers to the following: if the goal of the state measure that restricts the legitimate right, and then the proper examination, and thereafter the alternative measures, and then the test of proportionality in a restricted manner. So here we're talking about the same structure. Now, what happens when we work with this specific study object, but within a context that is strongly crossed by inequality and social exclusion, that, as the Inter-American Court tells us, amongst other offices that say this, we see the prevalence in the region, and this impacts in a lack of protection or delegation or denial of the effective enjoyment of social and cultural aspects, impacting in an unproportionate manner in groups which find themselves under vulnerable circumstances, girls, boys, and teenagers. And of course, feminization is underscored in poverty in young and adult population. Now, this is a quote that I come from Ferrer Macreol in the Cupibaral versus Guatemala, but also this diagnosis of this strong inequality from a structural standpoint that goes through the region. You'll find it in the reports of ECLAC and on the thematic aspects of the Inter-American Commission on Human Rights, and of course in jurisprudence within the Inter-American Court. And here, because I'm with you in this space of the Constitutional Study Center and of the Mexican Court, I wish to, taking into account precisely that this situation impacts very much generating greater poverty in women, young girls, and teenagers, we have to keep this in mind. This is what is mentioned in the protocol to include gender perspectives in a work carried out by the Constitutional Work Study and the Mexican Court that said that in a certain way, we are somewhat accustomed to the inclusion of the control of conventionality, or in other cases, to discuss the control of conventionality. But what do we need to couple or connect? Well, the simile that comes from the general recommendations of the Committee Against All Forms of Discrimination Against Women of CEDAW. And we have to connect this, and this work to achieve better standards would have to take place based on the general observations and general recommendations that come from the other United Nations committees. Therefore, we are left with proper standards. And if this is the path, well, there's still much to be done. So it's not only that we need to keep in mind precisely when we carry out, according to me, a proportionality test, the disadvantaged position in which women, girls, and teenagers find themselves under the light of the general recommendation of CEDAW's 33rd recommendation, we also need to keep in mind the 25th, which properly explains what is this inequality position consist of, in which women, girls, and teenagers find themselves. So let's think, when we are working concerning the proportionality test on social rights, we have to keep in mind that there are determined or specific collectives which find themselves in a situation which pulls them in other words, under these unequal circumstances. And what does it mean to eliminate direct and indirect discrimination, to modify cultural patterns, and to eliminate gender stereotypes, and to improve the position of women, girls, and teenagers de facto? And this is crucial as well. And this nurtures the obligations in terms of economic rights, social rights, and cultural rights, transforming the structural causes of this unequal law, and to identify the structural causes, in other words, with regards to inequality, and to transform them. Therefore, if until now we talk about proportionality, the Latin American context, economic, social, and cultural rights, and a disadvantaged or vulnerable position in which certain collectives find themselves, the question that I invite you all to ask yourselves is, which is the emancipating potential of the proportionality test? And if this is a porous framework which allows the specific voices to present their arguments, including precisely those voices which have been invisibilized or silenced. So amongst those voices, we find women, girls, and adolescents, which find themselves under poverty, indigenous, or indignified circumstances, and other things. I hope you understand which is the emancipating potential. Do they have it? They don't have it. We have to ask this question. I believe that we do have to do so within the context in which we find ourselves. Therefore, I'm asking these questions, and you can find these questions on the other side of the ocean. Martina Guerrao, Chisca Po, Veronica Undurraga, Martin Aldao. And here I wish to refer to that this is one of the questions that we formulate in a book that we are coordinating with Bo Restrepo and myself. A potential emancipator, we have to ask, because of what I told before with regards to the lack of access to the enjoyment of social, cultural aspects for specific collectives. So I think that this needs to include something else. We need to explore further the uses of proportionality tests from another perspective. Until now, the use of proportionality tests and the studies that were carried out went hand in hand with what courts do. We might say that these are focused courts. Research or investigation is focused on the courts and the higher courts or regional courts as well. But what happens if we work with the usage of this tool, talking about activists and defenders? And what happens if they're using it for a framework to talk about conventionality and a norm of a condition, for example, in the case of social and economic rights? Therefore, the question and the objective and the amplification. Therefore, this is a hypothesis. What comes about when we look in a broader sense? If it's removed from the court, what happens is presence in other spheres. In the legislative branch, this was much present in the argumentations heard, for example, in the Nations Congress, when they discussed the voluntary interruption law on pregnancy in Argentina, and thereafter it was approved back in 2020. So therefore, here we have a strong presence in a sphere which is not a court on a subject matter, which I believe it has to do with cultural, economic, and social rights, because voluntary interruption of pregnancies has to do with the autonomy of women, girls, and pregnant women and teenagers, but it also has to do with rights to health, reproductive, non-reproductive. Hence, we have a presence with a positive result in the sense that the voluntary interruption of pregnancies was solved. In other Latin American contexts, very adverse, by the way, maybe they comply with the BET application. And this came from an interview with Martina Arau with regards to a defender on human rights. So he said, generally speaking, that we always present something creative because in the end, everything has been lost. The court is adverse, but we nonetheless presented to it, is against. He said that the system wishes to generate lack of hope to avoid litigation. And he ended his interview saying the lack of hope is intentional, political. And this, I learned it from the feminists. So yes, although in maybe other contexts, it's quite against, and this idea of betting, but I bet maybe the result will not be favorable. So with these two ideas, I go on to the next slide. So what comes about when we look at this broad image, which not only do the courts have the right concerning economic, social, and cultural rights. As a structure, in some parts, it comes about as an express structure, in others as an analytical part, and the proportionality test with its 4 steps. In certain cases, maybe they're not express but implicit steps, but you have to be careful with this because we're talking about the Latin American context, and even more so with the Inter-American standards on international right on human rights. In other words, I wish to say the Human Rights Court, the Inter-American Court on Human Rights, and very important what comes about from the protection, universal protection system on human rights, and what comes from the sentences of the courts in the region. And in terms of social rights, this would be, once again, like a hypothesis. Not only do we see this analytical structure, but also progress goes hand in hand with the application of these material standards. And what is it is? It's a great window of opportunity because for the following. And it's a great window of opportunity. I'm always talking about the perspective of human rights advocates and activists. Why? Because it helps, first of all, to include those that are excluded in that provision and to provide it with an argumentative framework. It makes it powerful, well-known for the most formal spaces where this needs to be presented, being it audience or within Congress or being this at the court level. And what's at stake in that toolbox? The 3 versions of the proportionality test or exam. The classical one, which is proportionality as a provision of excess. In other words, the state does, but it does something that restricts too much and there is no justification about it. And we're going to look into it. This was, and it still is, fundamental to declare and to attack inconstitutionality and conventionality of a legislation that prohibit abortion in all the alleged situations. Let's go to the example. The big, large constellation is proportionality in case of regression. For example, the state, it recognizes it has to carry out to truly enjoy the rights, and then it goes back. It interrupts, and that interruption is going backwards. I'm going to give you a graph on the right on education. And then the third one, which generally is less worked upon, but it's very relevant, is proportionality in case of insufficiency or omission. In other words, when the state measure has been attacked is an insufficiency or insufficient, or directly nothing took place. And this, for example, I can explain this with the housing circumstances. So let's think about this. We see the 3 versions of proportionality in terms of economic rights, social ones, and cultural ones as well. And plus inter-American standards on international law, human rights, and of the courts within the region. They imply a great window of opportunity for advocates on human rights and for activists, so as to translate these claims from the basis in interpellations. So the first one, for example, Artavio Murillo against Costa Rica. Wasn't it fair? Wasn't it exact? It wasn't exactly a case of pregnancy interruption, but we know that this sentence or the argumentation that took place here permeated and went through all the foundations that were used in the different arenas in the region so as to be able to support the constitutionality and conventionality of voluntary interruption of a pregnancy. Why? Because the argument is that under Article 4.1 of the Inter-American Commission on Human Rights says that it protects life from the moment of conception. Generally speaking, it would be admitting possible regulations and giving it the space that might condition with other rights. In other words, it's not absolute. Therefore, and here, thereafter, the court carries out a proportionality exam. We had said it had to do with fecundation, assisted fecundation, and the conclusion is the total provision of fecundation assisted in Costa Rica is unconventional. Why? Or fertilization, because we have an act that restricts the autonomy of women and their health, in an unproportionate manner. And it applies specifically the proportionality exam in this sense, in a restricted manner. Here you can see the details. So what is it going to say? I'm going to quote Veronica Undurraga, keeps in mind precisely, and she carries out not only a legal work, but empirical job with regards to the argumentations utilized in the region so as to attack and the unconstitutionality of the respective laws in terms of abortion, to say that from that analysis, the use of the exam on proportionality comes about together with the interpretation of constitutional rights and human rights as well, nourished by these international standards that include a perspective or a vision and which are sensitive to gender. So up to this point, the first big engine or window of opportunity. Second one, prohibition of arbitrary regression. Here, what we're talking about is an action, because the interruption and going backwards is a state action. It's not an omission, neither an insufficiency. And then it interrupts, but interruption is a decision. For example, in the case of González Lue versus Ecuador, it's an arbitrary non-regression provision. The little girl with HIV and with another disease, blood disease, is admitted in a school for 5-year kindergarten. But when they find out that she suffers from HIV, well, first of all, they're being abused, and she's kicked out of the school, and she cannot go to any other school. So therefore, she cannot go to school whatsoever. In other words, there is a strong negation of the right to education and basic education. In other words, this is something which is a guarantee on behalf of the state. First of all, it guarantees, and then it goes back and removes. So the court carries out an intensive proportionality test. Think about the reference, the test of least aggressive alternative measures. For example, the means chosen. For example, expulsion is the most dangerous and unproportionate measure. In other words, the most aggressive one and unproportionate, those available to comply with the objective of protecting, on the one hand side, yes, of course, integrity, health of girls and boys, of school staff, but on the other hand, that of guaranteeing the voice and the right of education of Talia, this little girl. And what it says, there existed. They carry out a test, the risk was minimum. contagion risk was minimum. And on the other hand, there existed some preventive measures for, in any case, within the framework of the schoolyard, they might prevent any type of contagion. But I insist, it was minimum contagion. There was no issue whatsoever. So here we can see prohibition of non-arbitrary regression, which is extremely important in terms of economic, social, and cultural rights. And here I'm explaining it with an individual case, that we have to keep this in mind. Everything that, the so-called austerity measures and their implication when they're austerity measures, when they affect economic, social, and cultural rights, well, what we need to assess is non-arbitrary regression. And when we see the gathering of criteria that the Economic and Social and Cultural Committee carries out for the assessment, non-arbitrary discrimination, non-regression, well, we can see there that it's a fundamental part, the need test, in other words, to assess, did an exhaustive study take place for the possible options to avoid limiting the social right in question? And the other question, did they especially take into account the unproportionate impact? And this has to do with the restrictions towards the rights to people that find themselves under vulnerable and disadvantageous circumstances. So this is rebuilt with the 3 steps of the proportionality exam. And here, to provide you somewhat publicity of the constitutional review, it was published yesterday. It refers to the Christian Curtis article and others on the prohibition of regression in terms of DESCA and lights and shadows, or luces y sombras, in the formulation of criteria. But beyond that, when we see the criteria, we see the centrality of the proportionality alternative measures, and within proportionality in the strict sense, to keep in mind as a considered mandate position of the restriction and how that measure impacts the rights of the people that find themselves under vulnerable circumstances or under structural disadvantages. Now, the third formula, it's the proportionality exam in case of insufficiency, which is also crucial when we think about our context. Thousands, millions of people that still do not have access to dignified housing, and this impacts in an unproportionate manner women, girls, and adolescents. And here, the structure also with these 4 steps, alternative, adequacy, and proportionality in the strict sense. And in the case, this case continues being a paradigm, which is the case of Kisber Castro against the government of the autonomous city of Buenos Aires concerning the right to housing, health of a woman and a boy that were facing severe disabilities and lived on the streets of Buenos Aires. So the debated matter, if the actions that took place on behalf of the autonomous government of Buenos Aires that recognized, and it still recognizes that it has a housing emergency, well, they had to do something to guarantee the right to a dignified housing as in Article 14 bis of the Argentine legislation. So during this judgment by decree, a 5-month subsidy and housing plus the possibility of an extension for further 5 months. But beyond that, nothing else. Hence the big question, if precisely this action or these acts that have as a diagnosis the housing emergency that also pursues in turn the guarantee of dignified housing, well, is it or isn't it sufficient? The actor attacks precisely through the habeas corpus or amparo the action as insufficient because after 10 months, I have not solved the housing emergency because of the structural disadvantage in which that woman and child find themselves, and surely they shall return to live on the streets. So once again, I'm reconstructing the Petracchi vote, the judgment of the Supreme Court. What can be reconstructed is a proportionality test with the 3 steps, and also it includes the proportionality test with this conciliation mandate to keep in mind, especially if that measure or that state action had and considered the condition of vulnerability under which specific people find themselves, like women, girls, boys with disabilities that live on the streets of Buenos Aires. Adequacy. What's the conclusion of the court? This is insufficient. They didn't keep in mind the particular vulnerable situation of the stakeholder and her child. But to reach that, the interesting thing is to reconstruct the argumentation. The first part can be rebuilt as an adequacy test. Not only did they approve the selected means, but they also carried out a mapping of the accessible means at that moment. In other words, the group of housing policies for emergency purposes that they had right there and then on behalf of the local government. On the one hand side, a credit line for housing purposes, and on the other hand, a grant or subsidy, 5 months, renewable for another 5 months. And on the other hand, the so-called state ins. So the first one, it firstly says this is not adequate to guarantee a dignified housing solution for people that face housing emergency. A credit, what is it? For the rent or for purchase? They only give it to people that have a minimum wage of 2,000 pesos. And that, of course, first of all, they need a formal job, and they need, at that moment, I wouldn't say, the minimum wage, but it was a little bit over the minimum wage. What's the problem with regards to this measure? It doesn't keep in mind the structural disadvantage situation of women. Why? Because the majority of women, poor women, work under informal situations in what we call informal economy. And that's an emergency. And this means it's not adequate, not from a quantitative level, because 2,000 was a good way. It wasn't a good wage, neither from a quantitative level, nor from a probabilistic angle, because in the short term, it wasn't either, in the case of this woman, probable for her to find a job with a 2,000 peso job, because there's something else that was not kept in mind, that taking care of the child is totally invisibilized. The court does not think thoroughly, but everything that has to do with caring for children, we know it's a job, especially carried out by women, girls, and adolescents. They do not get a pay. It's not recognized, and therefore it's not recognized, so therefore it isn't redistributed in terms of public institutions that will be in charge of taking care of girls, boys, and of elderly individuals or people that need special care. Like, for example, this child, he needed help 24 hours a year. He had psychological and motor disability. The subsidy was insufficient as well because it's not probable that after the 10-month period, she can save to rent something or to purchase something to find a dignified housing situation. And also because, on the other hand, when there is no formal employment, you cannot carry out a formal leasing contract. Hence, you need to go to a family hotel, which in comparative terms, they're of bad quality because the services are extremely deficient and in turn, they're expensive. So the grant is to pay that. And lastly, the inns. First of all, they're insufficient. Why? Because they're transitory, just for the night. When night is over, people need to leave the inn. Therefore, that's not a housing situation. It doesn't allow the development of family life. And less even so, they solve, housing solutions. So this goes together with something else. There are not sufficient inns. There weren't sufficient inns. And the most important thing is that an inn is a big warehouse with beds. You can do nothing whatsoever from a family perspective, and they're divided between men and women. So in this case, it was going to be an issue. Therefore, none of the chosen or established means was adequate to provide sufficient response to guarantee the right to a dignified housing situation for the woman and the child. The exam continues being alternative measures. Alternative measures, we need to compare the established means by the government of the city of Buenos Aires, the grants up to 10th month period, and on the other hand, what might be a means that would guarantee and provide the conditions to be able to enjoy the effective right to a dignified housing situation. And to underscore, the court sustains that under these circumstances, what is needed is a state action integrated. In other words, where the different state agencies in a coordinated manner will provide an answer to the woman and the child, which will guarantee on the one hand side a dignified housing, and on the other side, this is where the topic comes in somewhat, which guarantees care. What for? For the woman to be able to organize her own life plan in terms of autonomy, and also in terms of the possibility of getting a job. Now, here, things aren't clear, and the state allegates that it has no resources, and we know that's the typical argumentation on behalf of the state. So, using international law in the human right law, what does it does? The recommendation is in the hands of the state, and this is crucial. Why? Because it's saying that they do not have resources, it's merely a stamp. The court says, they don't have sufficient funds. It's merely a stamp. They say it's not enough. And to be able to have budget lines and the sub-budget lines, and to show that you executed the whole budget, and that you were not able to guarantee and generate these conditions. Generally speaking, the states do not wish or do not generate these examinations. And in that case, they continued utilizing because it wasn't presented. International law was not utilizing human rights, but we know that the standard is they need to show that they adopted all the available resources, and all the available resources, not only the monetary or financial resources, but all the available resources that the government has. Therefore, here, juridical law is interesting because from a local perspective or local governments, there are many properties which are vacant, and they have been inherited, but they're vacant, and these are empty homes. Therefore, a first court judge spoke about a social trust fund. In other words, in a transitory manner, this was a way of guaranteeing the right to a dignified housing of people that found themselves in these emergencies. The court didn't go so far, but we see that in terms of alternative means, we might think of many. And lastly, proportionality in a strict sense. And this is interesting because we need to keep in mind how intensive is the restriction to the right to housing and the health of the child. In other words, we've seen how it's integrated because this precarious housing situation, which as a matter of fact, this house for the 10-month period, as a matter of fact, worsened the health of the child because health systems were very deficient. The child contracted, I believe, hepatitis. So, his physical disability, the severe one, they added hepatitis, and he went with regards to his capabilities from a motor perspective, because one of the characteristics of the child, to communicate with the mother was screaming. So when the mother cooked, the mother could not take the child to the communitary kitchen because the child used to scream to communicate with their mother. So those that shared that communitary kitchen were bothered. Therefore, the mother was only able to cook within her room, and eating improperly did not allow the child to develop properly. And chewing, so this meant a regression in the development of the child. So we see that in this case, although we do see the right of health and housing to the child, fine, but the restriction intensity of the rights of women, for example. In other words, it's not the right only for housing purposes, but also the right, or rather, we see invisibility concerning the care and no support whatsoever for the care provided to the child to be shared with public institutions, in other words. And here we have, and we need to keep in mind the special situation, vulnerable situation that people living on the streets or homeless, we have to take into account gender, girls, and disabilities. So an interfering right, very intensive, and the state, and merely as confirmation, lastly, well, the lack of resources. That is what the state said. And the result with regards to the decree has attacked because of insufficiency precisely the part which implied a violation to the right to housing and health of the woman and of the child. With this, I will reach the end or my conclusions The conclusions, in other words, to continue talking, are the following. To think about this emancipating potential of the exam in terms of economic, social, and cultural rights in connection with national law of human rights and, of course, with the inclusion of gender perspective. So what I do believe is that it's a very porous framework so as to allow the hearing of those voices which are usually marginalized voices in all these debates and public agendas. And therefore, we need to continue exploring the usage more with regards to this framework from the vision of activists, advocates on human rights, that precisely, this has to be very clear. I'm not saying that this will change the world, but the claims in a broad sense that need or that are seen in terms of the claim to rights, and then they're translated into specific claims at an administrative judiciary level and also at a legislative level. Well, generally, they're part when we think about the social movements of strategies with a greater scope. It's not the litigation, the only action strategy, but because generally speaking, it comes along with other further actions. But when within these further actions, we look at this one from a legal standpoint, we can see that this might be a way of channeling from an argumentative level the economic, social, and cultural rights, and to continue thinking through the use of these three structures that we had mentioned before, and seeing that in certain cases, it had a strong presence, successful one as well, and that even in those cases in which the general context continues being very unfavorable, there are nonetheless, well, not in those reasonings, there's still hope. So thank you very much. And this is it for me. Thank you. Thank you, Laura. Thank you so much. You have stated problems that have come about throughout this conversation, and you have brought them to light. You've made a synthesis and provided new ideas. So there are many questions, by the way. I don't know if I will be able or we will have time to ask them. That's what I wanted to say. If you can accumulate them, it would be better. And if not, later on, you can send them to me via email. Perfect. Of course. I would like to have them. Now, there is a question, or there is a group of questions, which are the questions concerning the emancipating potential. First of all, they're very much interested in this idea. Many of the individuals which are asking, what is the emancipating potential and who does it apply to? Who does it emancipate? And if it's an individual matter, emancipating potential with regards to the person that states the claim of fundamental rights from a legal standpoint, or it's an emancipating aspect if social protection of, for example, the case of the mother with a disabled child, for example, that the child is subject to a new disease. And they ask about this idea from a judiciary standpoint, maybe does not have the contrary, a contrary effect. In other words, the resources of these social movements, different stakeholders, in other words, social resources to be able to focus towards individual human justice, or to leave aside, the political arena, the claim arena before the democratic or the individuals elected democratically at Congress, or in these agencies, in other words. So that's more or less the first big group of questions with regards to the emancipation character. And with regards to that, I'm going to take advantage that you're here with us. I do have a doubt. If you know the work of Rodrigo Primni with Mauricio Garcia with regards to emancipation character of the sentences of the Colombian Constitutional Court, I believe it's a work that took place in the 90s. And if there's some sort of link between that idea of the sentences of the Colombian Constitutional Court and its emancipatory character, you are stating. Well, thank you. Thank you so much to all of you for these very interesting questions. I believe it's good for these questions to take place. First of all, I wish to say something. I feel that these discussions with regards to adjudication methods became extremely abstract, first of all. And secondly, in a certain sense, they're like blocked because it's being discussed. So therefore, we have to go back to the material down below. So thank you so much. The emancipating potential, I know that it's quite strong, but the working line that talks about the language of human rights as a way of being to in a language that appeals to others with regards to the claims that you others have. So yes, we continue seeing that people, as a matter of fact, those that we might call those that are found on the mountains, on the plains, they refrain or reframe, and return them in an enriched manner. It's not that they go up from upwards downwards, but downwards upwards with new senses. That's what it means. In other words, in the measure in which they continue fulfilling that function, it makes sense, of course, to ask ourselves this question. If they continue utilizing, it makes sense. And if they continue so, then we see that this way of continue utilizing, why do I have to go on if it's going to say, if it's going to achieve, for example, this other thing, and we can't achieve it. So, the structure is there behind this adequacy. But if you wish to do this, why don't you do it through another means? And either way, they won't cut off the pension for invalidity purposes or for this or for that. So there are alternative measures. And why lately do I have to carry all these, in between commas, all this state policies if there are other people that show or demonstrate a different capability in terms of economic, social, and cultural goods, which of course do have an influence in decision at a local, national, and multinational level, where it would be. So, the argument in this sense, they're working with the restrictions to my rights. They're working with restriction intensities. I hope you understand. It's a structure that is utilized much in daily life. So yes, of course, that's what it might mean. In other words, it would be like a way of reframing the discussions that take place individually or collectively. Because on many occasions, the individuals have a collective backdrop, the context. Let's look about the case of Madam Kirchner Castro. She is going for an individual amparo or habeas corpus purpose. But what about the housing emergency? Her. And then the question, did it have, was the child infected? Yes, of course. And here, once again, the part, in other words, it did. And what happened thereafter? You know, but this needs to be clearly stated. The arguments, I'm going to give you this image, the arguments conveyed, and it was clearly shown that that action was insufficient. Of course, not only for Kirchner Castro, but also for Kirchner Castro and all the people like Kirchner Castro, but also those that were facing housing emergencies. But thereafter, what did the court do? It worked on the precedent in such a way to say that it only applied to people under that lived out on the streets or disability or equivalent. For example, a man alone, homeless, between commas, 10 months, and that's it. However, that person is going to face the same problem if they're under a structural disadvantage, poors, or poverty. But I do see the same reasons. I find myself under the same circumstance, and why not I? So that's a strong argument. The other point or item presented, if this doesn't create strength to the political action, well, what I stated is that on many occasions, they search for individual amparos or collective ones. They're part of broader strategies, right? So if that collective or that movement thinks that within its strategies, it's through the judiciary branch for an important strategy, I don't think it'll obtain the dimension of a political discussion. On the contrary, what they're putting on the table is in part, and of course, rightly so, using that option as part of putting that table in the political agenda. And the case is not clear in this. I'm going to give you an example in the Argentine case, and surely this might have taken place in Mexico as well. It's the case of FAL in Argentina. It was still when we didn't have voluntary interruption of pregnancy. The law is a recent one from 2020 in the FAL case. In constitutionality, the criminal code is attacked that admitted abortion because of rape, but only in the case with these words, by the way. It was fully racist. You know, that part of the code that says in case of a crazy woman or something else. In other words, only in that case, think in that sense. So the court said, it's all rapes because, you know, sexual abuse, there's no will whatsoever on behalf of the woman. So concerning the other permitted abortions, because, you know, the life of the mother is at risk, for example, or the health of the mother, and an encephalic fetus. So yes, it increases, and there's an interpretation. In other words, any type of sexual abuse or rape, and that judgment was a judgment of the Supreme Court of Justice. It didn't place a discussion out on the streets. For the women's movement in the feminist collective, in a certain way, it empowered that judgment. I believe in 2012, it obtained greater visibility through the Me Too, but it came before. Of course, it had nothing to do with that, but greater visibility. So therefore, we have the discussion in 2018, which does not achieve a few votes at the Senate. It's not approved. It's not passed the legality of the abortion. And in 2020, So in that case, I do not see that the FAO case has created a problem or an obstacle concerning this discussion on the web. You know, it was very interesting. There were protocols, and precisely the reaction between the local governments and between commas came about of not wanting to apply the protocol. So on that side, it's not everything or nothing. Every time it'll make the political discussion be stuck, and especially, or not necessarily, and I also wish to talk about this. I worked on this question not only within the courts, but at a parliament level, Congress level, preliminary hearings, full debate, or when the rounds are taking place together with specialists or representatives of civil society, of the movements, and human rights organizations. And I have to say that in certain cases, from a judiciary, it's necessary and urgent. The case of criminalization of abortion at the present, there are thousands of women in the Americas in prison because of this, living in prison with no reason whatsoever. Some of these women have been there 30 years. If we look at the case of El Salvador, there has been a regression. El Salvador allowed abortion in 3 alleged situation, and then it goes back. It deletes it. It's prohibited in all the circumstances. So the right of gestating women, adolescent or child, whomever, they are invisibilized from a norm standpoint. So of course it goes against the standards established by the court on Octavia Murillo. It's not sustainable. Lately, you also saw a judgment, I believe last week, right? Or 3 weeks ago, 2 weeks ago. And you looked into this precisely, and it's part of the foundation of the judgment, therefore, or the sentencing. So I always say, maybe let's place ourselves in the shoes of those that are claiming and not make something seen as natural our positions, in the sense that, and this is very interesting, it's expressly said, those that are incarcerated are poor women, in other words, in those states where abortion is still criminalized, and even obstetric emergency. In prison, we're talking of women in prison, girls and teenagers, poor. And we might continue providing examples. So the answer to the judiciary path, it's not everything or nothing. We do not leave aside the political arena. And the other has to do with the sentence of the Colombian Constitutional Court. Yes, I do believe so. Diana Beatriz stated precisely, and the sentences of the Colombian Constitutional Court during its golden age, that essay was written in its golden age when the Constitutional Court seriously took into account the mandate of the Constitution back in 1991, the part that has to do with the rights and the social part of the state. And, you know, it's wonderful because there is an amparo or habeas corpus, which is completely informal and free. So when you have that, you can see that access to justice legitimately is broadened. So we channel there precisely what, after different decades is not achieved through public policies. If there is a right, why don't you guarantee the right to basic education, for example? In some of those cases, because of the right to basic education and health. So yes, of course. And I believe that the court had a very important role with properly fundamented sentences, determined that that was probable and possible. And thereafter, there was, in between commas, changed the profiles of judges, men and women, shows the faithful demonstration that it's possible. When somebody takes seriously the Constitution and interprets it, the result is, with regards to that first jurisprudence by the Constitutional Court of Colombia. And this, in between commas, is not liked by those who do not wish. Lastly, and here maybe I'm going to quote an ECLAC report, to lose their privileged position. But if we take into account human rights in a serious matter, that first court demonstrated that it's not only possible, but probable as well. Thank you, Laura. No, fine. Thank you so much. Now that you're saying this, I thought about the discussions that have taken place with regards to abortion. And some have been focusing on certain rights, freedom, right to life, for example. But right to health has been left aside. It's a right that is in a certain way linked, but there isn't much discussion. And it's related more to freedom. You know, I'm just thinking out loud based on what you said. I wish to say something. This is why I brought it to DESCA, because it's a matter of health and public health. Because the lack of access to contraceptives, the lack of having access to comprehensive sexual education for everyone, girls, boys, women, everyone, on the one hand side is a right to education, sexual integral education. Albarracin, let's think about that versus or vis-a-vis Ecuador, the Inter-American Court. And on the other hand, access to contraceptive modern methods, sufficient, not at 300 kilometers in distance, physical access. And on the other hand, quality as well, modern contraceptive methods. And on the other hand, of course, intervention through medications or surgically. And there are different options to carry out voluntary interruption of a pregnancy. But you're right, it also has to do with health. It's public health issues because it implies access, and also it's a matter of education at a university level because it implies new training of health providers. If one understands social rights, regardless if you agree or not with this vision, you know, the willingness to be able to guarantee from a judiciary standpoint, legislatively, constitutionally, certain basic rights for a proper living, you know, the data provided by you, which is the incarcerated population when we think about topics like abortion, for them to be women, teenagers, pregnant women, with certain socioeconomic characteristics, well, it also talks to us in terms of equality, inequality, and poverty. Yes, absolutely. The same norm has a discriminatory problem in terms of gender. The interpretation frameworks also, it permeates all of this. And then, which are the bodies that suffer? It's the specific groups. And on many occasions in certain states, the rate of suicide is extremely high because when facing no options whatsoever, there are many girls and teenagers that decide, it's life or death. Life or imprisonment. She goes to the hospital, she's incarcerated, or they remain home, and probably they will end up dying, bleeding. And in certain cases, also, we have high rates of suicide. And all of this is painful. And this only happens with the bodies of women, which of course affects much the autonomy of women. Yes, it is a complete subject matter, and it deserves a specific space to think about this, or more spaces to address this topic. But the interesting thing here is that proportionality structure in these discussions is a protagonist when it's stated from a legal standpoint, and even when it's presented at the Senate, now at Congress, in preliminary hearings, and not only, also in terms of health, public health. Thank you. With this idea, let's go on to the next group of questions. There is much concern with regards to the link between gender, things, and methodologies, because when we talk about the proportionality test, if it's 2, 3 tests or different tests, if it's a utilitarian, I don't know, these concerns from an academic standpoint, these specific problems with regards to gender seems they do not come about. The method is one thing, and if the method serves, it can be applied in the same manner. It's a multifunctional tool. Thus, in general terms, I ask you, why do you believe this discussion is not so visible, or gender analysis, or gender impact, or how can this tool be utilized when there are people involved in the violations of rights in subjects or topics of this nature? And linked to what I just said, which is the impact of the tool in the analysis of rights, because sometimes we're under the impression that it's a hammer that does not touch the nail, but how can the rights obtain certain profiles and characteristics? They're being qualified. If you use the proportionality test or another tool or other interpretation methods, the result seems not to be the same, or not. We don't know. So the question is, in this sense, the impact of the test on the rights. And the other, some people notice that there is a combination of tools in your proposal. They're asking you if this is so, or if it's a mere impression, or if this is so, that the last stage, besides the proportionality test, which is obvious, there is an equality proportionality test with regards to the strict scrutiny. So with these norms and questions, okay, let's go on to the second round. Thank you. Again, I don't know if I'll be able to answer everything, but thank you. Very interesting. They do perceive very well those that believe that I am combining. Because I'm not working much from an analytical standpoint in the world of abstracts, but rather you saw that I was going to be working within a context. So maybe I'm working, let's say, in the intermediate stage between practices, trying. It's not only me, it's a group between the rebuilding from practices and trying to understand how it works within the toolbox. I'm not only working professionally. On this occasion, I didn't bring it along, but we also have stereotype analysis and equality tests from a structural and intersectional level, and to look at what is generating inequality, we utilize the Nancy Fraser model that looks at the multidimensionality of this in unequal circumstance, which has to do with an impact in participation. So yes, it's a combination. But it's good because in the cases, or those cases which are necessary cases to be worked on, because, rape or violations are extremely serious, the position in which they're found de facto, those people, even there are variations of the proportionality test, like, for example, the South African one that especially addresses to keep in mind, for example, if in this case of the degree of the subsidies kept in mind the situation of special vulnerability in which those people are live under the worst societal circumstances. So in that consideration mandate of proportionality in the strict sense, it's saying that, okay, we all know that there are people that find themselves under unequal circumstances for enjoyment of constitutional rights. So yes, of course, when you determine how restrictive is the intention of that person, is a person that is under those circumstances. So from the structural standpoint, from an analytical abstract level, okay, you can take on the one hand side proportionality and on the other equality, or if not, within proportionality in the strict sense, there's a specific consideration mandate that where in other words, in the equality test, there's also the proportionality test, because when it's established, if there's a clear reason or reason to sustain that inequality, it's analyzed in terms of adequacy in a strict sense. Good. This is based on the last question. On the first question, as you were saying, a hammer, and in the end of the day, what might we call it with regards to rights? It's true. The hammer is strong because it's a hammer. It should be, there is something here that when it was made or wasn't made, it wasn't, taken into account. It wasn't relevant. Hence, it's knocking on the door. And the first thing is keep in mind my arguments. In other words, it's like a deliberation obligation. That's the first thing. You have to go back and shuffle and say, fine, okay. If you include this, what might happen? But in a certain sense, it's the given and what's being questioned through, where is it questioned, taking into account the tools that constitutional law provides in human rights. The given, in other words, does it fulfill that function? In the end, there's a result of that. So the content comes from there. When the case Kirchner-Castro ended, other people said, this is the content. Sufficiency is not what addresses the actions included in the degree. To guarantee material conditions, you have to do more. So at the end of the argumentation, there is a content. There's no gap. And what remains, and the Constitutional Court from Colombia talks about sub-jurisprudential rules. So, and these are the standards. And with the Inter-American Court, it's the same thing. This might be merely through interpretation, or when these types of deliberations take place as a result of the reasoning or proportionality tests. But this, in the end, they're contained and they're not void. Now, with regards to the minimum content, it's a question, right? This model can be combined. You might have seen it. It can be combined. The model can be a rectangle with a minimum content or a floor beyond that. Content also demandable, which might be submitted to reasoning test, like in the case of South Africa, or proportionality test, equality test, etc. But with regards to minimum content, there are two large theories and aspects. One, relative and absolute. The absolute says this is applied to everything or nothing as a rule. And it's not bad because within certain contexts, because we can also justify it through a chain of substantive reasonings. And the other says negative, but with prioritized protection or special protection. If you intervene precisely there, then part of it is the justification of the state, and justification of the state wants to justify a restriction, then the justification is quite aggravated or high. We talk about a very intensive scrutiny test, so generally speaking, you can't do anything. With regards to this discussion, I left aside everything that I consider what is part of absolute protection, torture, forced disappearance. That's absolute prohibition, and it's applied everywhere. If this takes place, the consequences takes place. It's prohibited in my scheme. It's not part of the proportionality test. It's prohibited in many places. I don't know. Something else? I believe I answered everything, right? You did. In this possible world and the other possible worlds, these questions stated from the public and myself. Laura, this is the end of the allotted time of this conference, of this conversation. And thank you very much. Great pleasure having you with us. And we are left with many questions, concerns, and work. that needs to start being done with regards to social rights and proportionality test. Hopefully, we'll be able to know how you are progressing from the Constitutional Center. Remember, this is your home. Thank you, Diana, Beatriz. Thank you for telling me this is my home, because it's always a pleasure to be able to visit you. And to step on Mexican soil. Hopefully, this will take place soon. Thank you for this invitation. It was a pleasure. And to all of you that have accompanied us from the court's social networks and the platform of the legal houses, well, thank you so much for your questions. Also, thank you to all the people that organize these transmissions and that make this event possible. They're behind the cameras, without whom, of course, this would not have taken place. So once again, thank you to the staff of the Supreme Court of Justice, the people that work in the Legal Culture House, on IT, social networks, and of course, the Constitutional Center people that work there. And we invite you to the next roundtable that will take place at 11. David Burgess and David Martinez Zorrilla will be addressing the floor. David Martinez will discuss concerning the difference between principles and rules, and David Vilches with regards to his proposal with the analysis of needs. We'll see you in half an hour. Goodbye. Thank you. Greetings to all of you.